What's the relevance of that?
I see there is an obsession about Mr. Amupanda's political scientist. It's constantly being referred to, constantly being stated, my lord. So his evidence is the only evidence before you, my lord. And on that basis, you are being asked to grant absolution from the instance, in effect, dismissing the case before you, my lord. We restated the principles applicable at absolution from the instance. Yes. We need not repeat them, my lord. They have been stated in our heads of argument from paragraph 6 to 8, actually to 9, but we highlight, my lord, what is referred to in the Nice Kasuma judgment as the Damasep considerations at the stage of absolution from the instance. And equally, my lord, this is a constitutional challenge. And we have set out the burden of proof in relation to constitutional challenge, and we have done so from page 9, my lord. There is not much difference from what the defendants are saying, that all that the plaintiff need to do is to bring his claim within the four corners of the rights or freedoms that he is challenging. And we respectfully submit, my lord, that has been done. And once that happens, the burden shifts to the defendant to prove that any limitation on rights or freedom is being done for whatever reason, whether it's rationally, it's in accordance with the law, and etc., etc. That burden is on the defendants to prove that, my lord. And we have referred to the... Yes, my lord.
I've read your heads of arguments.
Yes.
I want you to answer two questions.
Yes, my lord.
That you have not dealt with. Particularly the argument, I think they are raised by the first and the 6th to 8th respondents' counsel.
Yes.
The challenge to the constitutionality of the Veterinary Cordon Fence.
Yes.
That challenge, the first to the 4th respondent, the 6th to the 8th respondent, and I think to an extent the 5th respondent also.
Yes, ma'am.
Have referred to the Animal Disease Control Act and the Health Act, which pieces of legislation sanction the erection of fences.
Yes.
For the purposes of controlling animal diseases.
Yes.
And if I'm not mistaken, Mr. Amupanda has also considered that the purpose of the Veterinary Cordon Fence, one of its purposes is to control animal diseases. Now, if the act is performed in terms of a piece of legislation, can the act be declared unconstitutional without challenging the validity of the piece of legislation?
I hear you, my lord. That is exactly the case that the plaintiff is pleading, and it's a case where the first order originates from. That it's the plaintiff is seeking a declarata as to the effect that this red line, this fence, was not sanctioned or was not the cordon fence, my lord.
The veterinary cordon fence.
Yes. So was not elected in terms of any law. And let me point to you, my lord, to paragraph 39 of our heads of argument on page 26 of the heads of paragraph 39. page 26, paragraph 39, it specifically says, although pertinently challenged by the plaintiff or the witness to point out any law which erected the veterinary cordon fence.
I want you to stop there.
Yes.
I want to give you an example.
Yes.
Your client is a lecturer at the University of Namibia. Am I correct?
Mm-hmm.
The University of Namibia,
Yes, my lord.
was established by the University of Namibia Act 1992 or 1994. I don't know which, yeah?
Yes.
It says there is hereby established the University of Namibia Act. Is there an act that erects and constructs a building?
No. But there is an act.
No. I want you just listen to my
Yes,
question.
my lord. I hear very well.
Is there any piece of law? Does the law have the hands, the head, and everything to perform the functions? Because you are saying there is no law erecting. Which law will ever erect
That's
the
what
veterinary cordon fence?
That's what I want to explain, my lord. What you refer to in the University of Namibia, it's hereby established.
Yes.
What all the other legislation being referred to is it says it gives different functionaries. Either the minister may elect a fence for purposes of. Yes, my lord. None of them says it is hereby established a veterinary cordon fence and give it that it runs from here to here. None of them says that.
No, this is what I'm saying.
Yes.
What does the law say? It gives the minister, the pre-2011 Act gives the minister, the post-2011 Act gives the chief veterinarian the right to erect fences to control.
Yes.
Now, and this is why and you agreed with me.
Yes.
That the veterinary cordon fence was erected for the purposes of controlling animal diseases.
Not by the functionaries that are entrusted with that.
That's not your case. That's not your case.
Our case is that there is no erection.
I can say to you is,
yes,
you'll die, wake up, resurrected, die, resurrected, and you will never find a law that erects any structure. You will never find it.
Not even Jesus died twice, my Lord.
Yes, but all that I'm saying, even Jesus Christ will never show you a piece of law that erects a physical structure.
Let me give you an
The erection of physical structure is done by hands of people. What the law facilitates and authorizes is the setting up of those issues. And there is an issue before you that either the minister or the chief veterinary officer may erect fences to control animal diseases. And you and your client have conceded that the veterinary cordon fence has been erected for that purpose.
No, my Lord.
Oh,
That's why I want to give you this example, my Lord. For example, if in Omaheke region right now, there is skin disease for animals.
Lumpy skin.
Yes.
Yes.
And the Prime Minister decides, I'm going to erect a fence cutting off the whole of Omaheke.
There is a veterinary cordon fence erected already to control animal diseases.
No, my Lord, I'm giving you an example.
Yes.
The Prime Minister just decided, I'm going to erect a fence cutting off the whole of Omaheke, and anybody grieving Omaheke must be searched. If they are found with meat, take it and burn it. And then I come to court and says, but these actions of the minister are not sanctioned by any law. The court cannot say, okay, because the animal health disease says the chief veterinarian can set up fences, because it says the minister can set up those fences. The Prime Minister was correct. It is correct. The actions of the Prime Minister are correct.
Mr. Ntinda.
Yes.
You see what? In the article that I gave you,
yes,
That article demonstrates the outbreaks of foot and mouth diseases from 1934 through to 1964. You know, and what government of the day, whether you call it a colonial government, a settler government, whatever it is,
Yes.
the government of the day attempted a number of methods to control and contain the disease. They first were killing all the animals. They would kill all the animals that are infected, up to about, there's even saying there's 500,000 cattle that were killed. Then they tried artificial insemination. They then did animal control. And that article tells you that from 1961 to 1964, that's when the cordon fences were erected. And 3,147 kilometers of cordon fences were erected at a cost in 1964 of 547,000 Namibia dollars. That's what that article is telling you. The fences were erected in terms of the Animal Diseases Control Act that was promulgated 4 years earlier.
As I said, my lord, I haven't read this article, but I wanted to when I'm seeking a declaration of rights, a declaratory order, that I need certainty in a specific area, my lord, as an order. And I challenge whoever is saying there exists a law to point me to that law. And I'm pointing, my lord, in paragraph 39, what the government is saying, what the fifth defendant is saying, and what the sixth to the seventh defendant is saying.
Read paragraph 39. Read
Yes.
it. Read paragraph 39.
Allow me, my lord, to do
Yes.
that. Although pertinently challenged by the plaintiff to point out any law which erected the veterinary cordon fence, none of the defendants were able to do so. The reason is simple, it is not there. And I point out, let me point out,
Wait,
allow me, my lord.
No.
Okay.
No. You're saying, although pertinently challenged by the plaintiff witnesses to point out any law which erected, I'm saying to you, you are asking the impossible. The law will never erect a fence.
My lord,
The law doesn't have the hands, it doesn't have the mouth, it doesn't have the eyes.
my lord, you are
The law authorizes the erection. If you could say what the defendants were challenged to do is to point out a piece of legislation which authorizes the erection of fences. It's a different ballgame to say the law that erected. It's two separate things.
whether it's authorized or elected, my lord, it's not there. That's what I'm saying.
Right, go ahead. You can proceed. You look for a law that erected the fence until I don't know when it comes back. You will look for it. You'll never get it, and nobody will ever point you to a law that erected a fence. Nobody will point it out to you.
Then
I would want to see that person. He can come to court and show us the law
If
that
there's-
have erected the fence.
Then if there is no law, my lord, you need to give that declaratory order that there is no law that, my lord, you are putting the physical, you are putting it at a very elementary level of
That's
taking
your
a...
language you use. It's not me putting it. It's you who lose it. I never
No, my
use
lord,
the
I
language.
never said you took your hand. No law says take your hands, you put the fence together.
Tinda, when I ask you,
Yes.
show me who built the house. Where is the law that built a house? What does that mean?
There is a, what I will say that there is a law that established, like the University
you
of
want to
Namibia.
convey?
It is hereby established the University of Namibia, called the University of Namibia. There
But
is
that's
no,
not what you are asking.
there is
You
no-
are asking the law that constructed the
no,
buildings
no,
that
no, my lord.
yes.
No, my lord, that's not our case.
That's what 39 go to. I'm sure if you go to a grade 8 child, ask him to interpret that sentence to you. They will interpret the way I'm interpreting it.
My Lord, if I can just that I...
That's basic English.
The question then, my Lord, is which law says they hereby establish a cordon fence, it runs from here, and these are the coordinates for this fence. That is what we are saying, my Lord.
All that I'm saying, is there a law that allows the erection of fences to control animal health diseases? Is there such a law?
Yes, there is the Animal Health Act gives the chief veterinarian officer power to erect fences when there is an outbreak of diseases. And the chief veterinarian officer can then say in a prescribed manner that I am electing this fence in terms of this power, and it is prescribed where those fences can be put, and so forth and so on. That law is there, right? And our case is that the chief veterinarian officer, even in the current context, has not done so in relation.
That's not your case. That's not your case at all. That's not your case. That's not your case.
It is. That's what I think, my Lord, that is our case. That
no,
there is.
You see, that Ntinda, what you are forgetting is that
yes,
what you communicate. And go to prayer 1.
Yes.
Prayer 1 does not identify a functionary. It doesn't. Prayer 1 says no law
yes.
authorizes the erection of. But I'm saying we have the veterinary, the Animal Diseases Act, the Health Act, which authorizes the erection of fences for the purposes of controlling diseases. And you see, you are talking of a chief veterinarian, which issue came up in only 2011. And history has it that the Veterinary Cordon Fence, the one that we know today, was erected in 1960. What was it? Sorry?
Where is that it was erected in 1960?
I've showed you the article.
No, my Lord, there is no such a thing. And that is
but there is a thing that says the Veterinary Cordon Fence was erected in 1896.
In 1896? That is the evidence before you, my Lord.
Who testified that?
Mr. Amupanda.
No, Mr. Amupanda. Was he there in 1896?
It doesn't matter, but it's evidence before you.
No.
Yes.
What evidence? Mr. Amupanda told me what he read in this book. He told me what he read in this book.
Evidence, my Lord.
No, that's not evidence. Okay. Go and revisit your law of evidence. What evidence is when I see something, I have seen it, I observe it, I will come and say, I saw that Ntinda driving a black machine. That's evidence. But if his court has told me that Ntinda was driving a black machine, that's not evidence. That's hearsay. I was told. I haven't seen it.
So we must believe that it's 1960 and not 1896.
I never said believe anything. All that I'm saying, and I said to you,
yes,
I want you to read that article. I want you to
read
it,
my Lord. I will.
So that you can see that when you come to court, you come to present facts, not a lecture.
Who was giving lectures, my Lord? The problem, this case is characterized by.
I'm not talking of a
unnecessary.
No.
When a witness comes to testify, you are being told you are giving a lecture. How else can he testify, my Lord?
He testified by what he has seen and what he knows.
Yes.
Amupanda was born maybe 133 years after that, 1896. How can he testify to that? Something that happened 100 years before he was born. Even before his parents were born. Most likely even before his great-grandparents. So how can he testify to something like that?
As a political scientist, he cannot testify to such things.
You see, that Ntinda, and I want to come to the political scientist. Mr. Amupanda, I didn't want to touch it, but I'm going to raise it with you. Mr. Amupanda is a declared politician, who is a partisan person. He peddles and advocates for a specific line. You cannot bring him to court and say the court must look at it, because he peddles. He has taken a decision. He has taken sides. So he can never be objective, because he peddles his own political ideology and what he believes. So you can't say he's a political scientist. If he comes to testify as an independent, and he never testified, he didn't.
So for those reasons, my lord, you think Mr. Amupanda cannot come to this court to vindicate any right?
If you don't know the reasons why he can come to court, then I cannot tell you. Because I am saying to you, Mr. Amupanda must come to court and testify to what he knows and what he has seen, not what he testified to what he has read. The argument with reference to legal authority. But you can't come and say that is evidence. That's not evidence.
It's not evidence.
No. Hear what you see.
Yes.
Don't put mouth. You are a legal practitioner. Our trade is language.
Yes.
Our tool is language.
Yes.
And what I am saying, Mr. Amupanda can come to court and testify to what he has seen, what he has observed, and what he knows. His testimony. If he comes as an expert, then he must come in that, and then he needed to file a Rule 29 report, which qualifies him as an expert witness. That hasn't been done.
In this context, my lord, the one by Mr. Giorgio starts from the beginning. I see Mr. Kamui, the one you described, my lord, started somewhere in 1934. And importantly, the version of Mr. Amupanda was under oath.
What I'm saying, he is giving me what Giorgio said, not what he has seen. He is giving me what Giorgio said.
So we must just.
And I haven't read the Giorgio. I'm going to read it and make my own findings on him also.
Thank you, my lord. That will help.
All right. Can we move on?
Yes. And I want to move on, continuing with paragraph 39.
Okay, let me go to the next issue. You see, as I've said, I've read your heads.
Yes, my lord.
The second issue. The second issue is the constitutionality issue that you say.
Yes.
Now, the law is clear. A party who comes to court to challenge the violation of his fundamental human rights, one must identify the right. I want you to show me in the evidence that's before court, in the evidence, and in the witness statement, where Mr. Amupanda identifies a right that has been violated, where he identifies, sets out the ambit of the right and the content of that right. Where is that evidence?
My lord, it's actually in the heads, my lord. I don't think
where
you raised
is the evidence?
I can just even refer to the heads, page 22, from paragraph 30. And I want.
Ampanda's witness statement was not long. It's 10 paragraphs.
My lord, you asked me where is the evidence.
Yes.
I'm taking you there.
No, it must be in that witness statement. It's not there. Rule 92, the evidence that you intend to give at court must be contained in the witness statement. It's not there. In the witness statement of Mr. Amupanda, there's no identification of any right, the ambit of the right, and the content of the right. It's not there.
Yes, my lord, should I proceed? My lord?
No, I'm putting issues to you, yes. And those are the issues that you need to address with me.
Oh, I will start here, my lord, if you may allow me. I will start at the particulars of claim, the pleadings. It's part of the documents which is before this court, which the court should consider.
Remember when you were during your opening statement, I indicated to you that pleadings is nothing but allegations.
Yes.
Which allegations must be substantiated
Yes.
by factual evidence.
Yes. That's correct, my lord.
Yes, now where is the evidence? That's all. You see, because at this time, all that I want you to take, you see, for you to escape absolution, you demonstrate to me the evidence that point to the elements of your claim. When I say, for example, he has identified the right to dignity, Mr. Amupanda then needed to testify as to the content, the ambit of that right to dignity.
Yes.
The right to equality.
Yes.
He needed to testify to that
Which he
for
has
him
done.
to make out a prima facie case.
Which he have done, my lord.
Where?
That's where I want to point you, my lord. You can start at paragraph 23
Of what?
of our heads of argument. We don't need even to go to the witness statement.
No, the witness statement is what I consider as evidence before me. Anything else is not
We have
evidence before.
cited it in the heads of arguments.
Paragraph? You say paragraph?
Page 23, the second last paragraph, my lord. Where you say the rights I was referring to in my Facebook are those provided in the Namibian Constitution, such as rights against discrimination, right to culture, freedom of movement and dignity, privacy, and others. I also bemoan to my legal advisor that we must take the issue with and seek recourse from the court of law so that this cruelty is ended in an independent and democratic society, and that no Namibian must be subjected to the same cruelty 30 years after freedom and independence. In addition, I was left undignified as a result of the manner in which the search and seizure was conducted by the fourth defendant was executed, particularly in that the meat bought for purposes of sustaining my family was burned in my presence, in the presence of the then onlookers.
Just stop.
Yes.
Just stop. Even those paragraphs that you have read to me, what is the ambit of those rights? What is the content of those rights in the
content?
The ambit and content, yes.
Yes.
These are conclusions. When you say I'm cruel, that's a conclusion. It's not a fact.
No, he said I was left undignified as a result.
Yes, that's a conclusion. When you say, Shafi, you stole, it's a conclusion. It's not evidence.
So, my lord, when officers come in, police officer come in my house and search it, and I come to court and say, they cannot search me without a warrant. And then I say, they searched my house, there is no warrant, they have no reasonable suspicion. I was left undignified by the manner in which they searched my property. I cannot come to court without a case, my lord.
You can't ask me what you can come to. All that I want to demonstrate to you is that what you are, when you say it's cruelty, what is cruelty? That's a conclusion. When you say you are undignified, that's a conclusion. What are the primary facts that will lead? It's for me to make not for you. When I accuse you of theft,
yes,
the law requires me to come to court and say that a Tinder took my vehicle. He took it without my permission. He took it with the intention to permanently deprive me of that vehicle. Then the court will come to the conclusion, on these facts, Shafi stole Tinder's car. You just can't come to court and say, Shafi stole my car. And then you expect the court to find that Shafi stole your car. Put those facts, the primary facts, that will lead to the conclusion of the secondary fact. You must place them before court.
This is a vindication of rights case, my lord. It's not a criminal trial where even the test is different. I'm saying that.
But Tinder, I don't know.
Yes.
Whether which class, UNAM class you went to.
It's not. No, my lord.
If the basic,
no, my
the
lord.
basic.
No, my lord. Let's not go to my personal.
No. You see,
It's not fair.
Okay.
That let me
just
go to my personal.
When you cannot appreciate the basic essence of a legal principle. The legal principle is set out the primary facts. Set them out. Now then you come and tell me it's not a criminal case.
The example you gave, my lord.
Yes, even in a civil case.
In a constitutional context.
Even in a constitutional. I'll give you a demonstration.
Yes.
Downsap came to this court and says he is being discriminated against.